Courts are pretty daunting places, I'm sure you'd agree. And for those in construction, facing a courtroom battle can be one of the most stressful, the most expensive and time-consuming experiences. Let's look at the top reasons why going to court should always be your absolute last resort. Reason 1, it's incredibly expensive. Court cases are notoriously expensive. Legal fees can add up really, really fast. A skilled construction lawyer, especially those who really understand this area of the law and specialize in it, they don't come cheap. In Sydney, for example, partners at a law firm charge anywhere from $450 to $850 an hour. And that's, of course, ex-GST. So you can just imagine how very, very quickly even a small case can run up to $50,000 to $100,000 or more just in legal fees. And if you're on the winning side, there's no guarantee the court will award you all of your legal costs against the other side, meaning you might only recover from the other side, if you win the case, something in the order of, say, 50 to 60% of what you spend on your legal fees. On top of that, don't forget that in addition to your lawyer, you'll likely also need a barrister, maybe even 2 if your matter is big enough and complex enough. So they'll easily cost you another $3,000 to $6,000 per day each, potentially even more. And what about expert witnesses? You may need support from them on technical matters if you need to prove a point. They want thousands of dollars a day for their services too, and they don't even work for you. They're actually there to inform the court and not you. For a matter to be truly worth your time and money to go to court, if it's a complex matter, you really want to think about whether or not you should be chasing anything that's under $75,000 to $100,000. The more complex your dispute, the higher this threshold amount might need to be. If you want to protect yourself from losing a small fortune in construction, there's really no shortcut but filling in the gap between $0 and $100,000 where it just doesn't pay to go to court, is to learn a bunch of other strategies on how to minimize or avoid altogether those losses. Reason 2, it's slow. Imagine a construction project that gets stalled, and not for just a few weeks or months, but years. As an example, it's not unheard of when you go to court that your matter can drag out for 2 to 3 years or more. Now, I know of a case that stretched out for 8 years. I was a junior lawyer at the time. I was involved in that case for 5 years myself out of those 8. Of course, that was a super large claim. I think it was in the order of $500 million. So it's not your average claim, but it's completely normal, quite frankly, for small matters that are somewhat complex to run for easily 1.5 to 2.5 years. Now, think about the toll that would take, not just financially, but emotionally as well. For many, that's a lifetime's worth of work gone into legal fees, and it's immense stress, all before a resolution is even close to being reached. Reason 3, it's uncertain. When a client walks into my office and says, I have a clear-cut case, my assumption is always the same. No case is ever clear-cut. So many factors affect the outcome, whether it's witness statements, photos, contract terms, email exchanges, opposing parties' finances, and legal technicalities, just to name a few. And even then, a sure thing can quickly shift when the other party goes, say, bankrupt, rather becomes insolvent, or produces new evidence that your employee conveniently forgot to share with you way back when you were looking for all this stuff at the start of the matter. So court cases are really, really unpredictable. And the winner often walks away with less, and sometimes much less than they hoped for. And on top of that, you basically have your future in the hands of other people, in particular a judge, to decide who is right and who's not. Reason 4, it's incredibly stressful. Lawsuits are intense. Now, forget the courtroom dramas on TV. Real-life litigation is often super slow, complex, detailed, and emotionally extremely draining. The language is legalistic, the procedures are pretty foreign to most, and the stakes are extremely high. If you're facing a situation where your livelihood is on the line, Losing sleep over your case becomes pretty normal, part of the experience. Nights spent worrying, waking up in cold sweats, it's an all-consuming process, and I don't recommend it. Reason 5, it's unproductive. A court case is not just a distraction, it's a massive drain on your productivity. For example, instead of looking forward, marketing to new clients, growing your business, so much of your time is spent looking backwards. You spend yourself or your staff or both a huge number of hours trawling through old emails, documents, site records, anything else that you can grab that will help your case. This alone can massively drain your business finances and, above all else, your energy and your drive that got you into your business in the first place. Reason 6, settlement offer pressures. Now, this one is not often thought about by people, but when you get into a litigation matter, what you'll find is that at the right time in the process, when the parties have understood each of their cases a little better, one party might find that they feel stronger or weaker than the other, and they put together a formal settlement offer to the other side. Now, that may seem harmless, right? But what happens with these offers, they're often called Calderbank offers or offers of compromise. And if you don't accept such an offer and you continue to go to court, their offer might have been for a certain amount of money. If a judge makes an award for an amount that is less than the amount that you were offered to settle, the other party is perfectly entitled to pull out the written document in which they made you a settlement offer, show it to the court after their judgment has been handed down, and when it comes to arguing legal costs and how they should be apportioned, normally if you won the case, you would be awarded your legal costs. However, that's when that settlement offer comes out and the other party would argue, we made them an offer some time ago. They would have been better off if they accepted that offer. Now, we have thrown away a bunch of legal fees and costs on our side because they failed to accept that offer. As a result, you may find that you win in the court case, but depending on when that settlement offer came in the process, you could end up paying their legal fees for quite a big chunk. And so in the end, you may have won, but not really have won when it comes to how much cash you get. So there are so many uncertainties in a litigation process that could result in substantial extra costs you didn't expect, even when you win. Reason 7, it destroys business relationships. Look, having a legal punch-up in the courts does not, for very good reason, appear in marketing textbooks. It's not a great way to grow your business relationships, and in fact, it leaves a pretty darn bad taste in the mouth of all parties involved. I'm sure that's obvious to you. Even if you win the case, the other party is not likely to go and talk to the people they know in the industry and say to them, oh look, it was a genuine mistake on our part, the judge awarded it on the other side, we're going to do better next time. I'm sure you can understand that that's not going to happen, and your reputation is going to be rubbished throughout the industry by the other side. Courtrooms, generally speaking, are very public and damaging to reputations. They should be the absolute last resort every time. And even then, issues of principle, in my opinion, really should give way to commercial sense if it's the longevity of the business that's the most critical aspect. Not doing so may mean you end up with a victory that is kind of bittersweet. Reason 8, courts deliver justice, not fairness. Now, this one's a little different to the others, but it's worth highlighting a really, really important fact, and that is judges are not there to dish out a fair outcome, which is what a number of people think is the role of the court. The role of the court is to dish out justice, which basically means to apply the law. Now, if we don't know what the law is and we're not aware of a particular rule or how a particular clause in a contract operated, the judge is not interested in what may seem fair. It's their job just to apply the letter of the law, the letter of the contract, or however else it might apply. So if you don't know the law, ignorance is no excuse, as we all know. If you did all the right things but didn't realize your contract, or maybe some piece of legislation said you were supposed to do X when you did Y, the judge has no choice but to issue a judgment that enforces the law, no matter how unfair it may seem. So, what's the alternative? How can you avoid the most common causes of disputes in construction? The answer is quite simple. Learn everything you can about two critical topics. The first one is construction contract law, and the second is a piece of legislation in New South Wales, and there are a number of others in each state. But in New South Wales, it's called the Building and Construction Industry Security of Payment Act 1999. Once you understand just these two topics really well, you'll become a master, in my opinion, at dispute avoidance. And there's so much more involved when studying these two topics. And it's not just knowing what the law is or a contract says, but it's also how to practically work with these tools. And they are tools. How to work with them in such a way that you avoid disputes, you clarify as much as possible up front, you pre-frame all parties involved to set expectations, and then you enforce what's fair as you understand it without needing to go to court. When you go through that education process, you become what I call a building bush lawyer. Someone who is not legally qualified, but who becomes very familiar with key fundamentals so they can see problems coming over the horizon and they know how to avoid them or when to get the right help at the right time, cost effectively, to deal with those problem areas. By the way, don't think you can't learn these two topics at a deep level. You most definitely can, and we've personally seen it happen. With the right training, you can pick up a topic such as the Security of Payment Act in less than one day and at a substantially high level. And I'm not talking about a sort of 1 hour brief summary seminar with high level fluff. I'm talking about a 5 to 6 hour seminar where you dive deep into how it works and exactly how to apply it, what documents to draft, exactly how to draft them, sometimes using templates we share with you. It really is a small price to pay to gain valuable knowledge on how to protect your business from non-paying clients or even from subcontractors who work for you, do poor work or incomplete work, but somehow think they're entitled to get paid in full. You can also learn key aspects of construction contract law in less than one day and get yourself and your team to a level of understanding that's actually greater than 99.9%, and that's just my best guess, but 99.9% of your colleagues in the industry. With construction contracts, you can learn how contracts are formed, and that's not as simple as it might seem. What clauses are super high risk and could destroy your business if things go wrong, and those clauses that are less of a worry. How to put contracts together so they're clear and fair while still protecting you. How to manage a project so you apply the contract in your favor but do it fairly. How to reduce the chance of a dispute from where more than 50% of those disputes start. And that's in scope of work. I'm sure you're familiar with that. But the number of disputes that start due to gray areas are huge. And there's so much more. So imagine investing your time, or that of your team even better, for less than one day and completely changing how you manage projects and your key business risks. So then once you have a solid understanding of these two topics, that's construction contract law and Security of Payment Act, you'll be able to have quick, inexpensive conversations with your construction lawyer, and then you can share with them precisely in a lot fewer words and a lot less time of your lawyer, therefore less expensive. So exactly what you're not sure about, and then you can get a prompt, very cost-effective answer to your question or your query. When you get educated, you avoid so many problems. You handle the smaller problems quickly on your own for the most part, and you tap into the legal expert on your team, presumably a construction lawyer, to handle the bigger stuff. And they do that more cost effectively than you could do. A trusted construction lawyer can help you develop strategies to avoid disputes in the first place. But if they do fester, they can help you redirect them before they spiral out of control. When you invest time up front to learn from these experts, you'll easily save, in my opinion, $10 to $50 or more for every $1 you invest in practical legal education. And this is not just money spent that down the track will save you this $10 to $50 for every dollar invested. I'm talking about helping you avoid giving up variation claims or suffering liquidated damages claims and a whole raft of other things that often don't end up in disputes because contractors generally just give up on them so they can hope to get the bulk of the money paid. Litigation genuinely should be your last line of defense. By understanding your rights, learning the law ahead of time, proactively managing disputes, you can keep your business out of the courtroom, which is absolutely the goal, and focused instead on what really matters. That's serving your clients at the highest level and getting paid for that, as you should. And I'll finish on this, and that is dispute avoidance has nothing to do with hiding in the corner every time there's a potential legal punch-up. It's actually quite the opposite. Dispute avoidance is about knowing what to do up front so that when the time comes, if you need to, you can point a massive arsenal of weapons at the other party, a lot of which they wouldn't even have expected, and then politely and diplomatically encourage them to choose a more amicable resolution, to take a friendlier path, do the right thing, and pay you. So if you'd like to explore ways that we might be able to help cost effectively train your team, I'd encourage you to visit our website. And if you click on the menu up top where it says courses, you can find out a bit more information about how we go about training people in the industry. And I'm talking about high integrity, high quality contractors who believe in what they do it to the best of their ability, and care about their clients. They're the people that we want to teach. If that resonates with you, you might like to find us on the website and apply to join one of our courses.